Solicitor General Kagan, I'm one of the others, so let me welcome you to the committee. I have been amazed and disappointed as to how the brilliant, trailblazing legal career of Thurgood Marshall has been portrayed by several of my colleagues. Justice Marshall came from Baltimore, Maryland, the city where I was born, the state of Maryland that I have the honor of representing in the United States Senate. Justice Marshall was one of the great Americans that have come from Maryland, and we're very proud of what he's meant to this country. It's interesting that this week, on July 2nd, we'll celebrate his 92nd birthday. And I must tell you, we've had a great deal of discussion about background. As you know, Justice Marshall was the great-grandson of a slave, and he grew up in a segregated country. I talked during my opening statements about how I remember attending segregated public schools in Baltimore City. I also remember swimming pools and theaters and amusement parks that were restricted as to who could attend and who could be there. So we talk a lot about empathy, we talk a lot about background, we talk about how important that is, but on behalf of the millions of Americans who have benefited from Thurgood Marshall's public service, I'm glad he brought his real-world experiences to public service. He helped make a more perfect union and made a real difference in the lives of Americans. I agree with the Legal Defense Fund in their release where they say, simply put, Thurgood Marshall helped make our union more perfect, and the legacy illuminates the highest possibilities for all Americans, yesterday, today, and tomorrow. Yesterday I talked about how we can ensure that the public understands how important the decisions of the Supreme Court are in their lives, and how I want American citizens to understand just how important what your role will be on the Supreme Court of the United States. I just one more time express this concern about following legal precedent and activism. I listened to Senator Coburn, and I must tell you, I think his definition of original intent reminds me of some of my colleagues' definition of activism. They use it for a particular purpose. Judicial activism is okay if you agree with the results. And I think it's the same thing with original intent. It's okay if that's the result that you want. But I want a justice who's going to follow legal precedent. I want a justice who believes that it's up to Congress to legislate, not the courts. I want a justice that is going to follow in the best traditions of protecting individuals against the abuses of government and special corporate interests. That's what I'm looking to. It's very difficult for us to pass legislation to expand rights. It's extremely frustrating when we finally get it done and then see the courts reverse legal precedent, reverse our congressional intent, and take away those rights that affect the people of our nation. So when we look at our Constitution, when it was created, citizens were defined very differently than they are today. Women and African Americans were excluded from the definition of we the people. But the real triumph of our Constitution is that we've overcome these faults. Chief Justice Roberts said, I think the framers, when they used broad language like liberty, like due process, like unreasonable with respect to search and seizures, they were crafting a document that they intended to apply in a meaningful way down the ages. The same point that you have raised before this committee about times change and how does the Constitution apply to current circumstances. The strength of our Constitution and the Supreme Court is that it advances rights envisioned by the framers to current times. Now, it's been a bumpy road on civil rights. We've made progress, and we have moved in the wrong direction. We've talked a lot about Plessy versus Ferguson. It might have been a pragmatic decision by the court at its time, but it was fundamentally flawed. There's nothing equal by separate, and we know that today. Then came Brown v. Board of Education, one of the proudest moments in the history of the Supreme Court, indeed one of the proudest moments in the history of the United States. The Supreme Court decision had real impact on real people's lives. Your opening statement gives me comfort that you will follow in the best traditions of the Supreme Court in meeting the challenges of change. You talked about a fair shake for every American. I'm going to mention that a couple times during our questioning. You also talked about the Supreme Court, of course, has the responsibility of ensuring that our government never oversteps its proper bounds or violates the rights of individuals. The fundamental opportunities of America depend upon those goals. Your grandparents and mine came to this country because of the opportunities of this country enshrined in our Constitution. In preparation for this hearing, I came across a Supreme Court case involving educational opportunity that you happen to be the clerk for the justice who wrote the dissenting opinion, Justice Marshall, in Condremos versus Dickinson Public Schools. Justice Marshall said that, and I'm quoting, "Today the court continues to retreat from the promise of equal educational opportunity by holding that a school district's refusal to allow an indigent child who lives 16 miles from the nearest school to use a school bus without paying a fee does not violate the 14th Amendment due process clause." Now, I mention that because I think Justice Marshall was looking at factual circumstances that were not present 10, 15, 20 years ago, but trying to use current circumstances under our law to advance what we all believe was the framers' intent of we the people. How do you believe the framers intended the Constitution to provide for the protection of people against abuses of government or special corporate interest?
Well, Senator Cardin, I think that the Constitution is a kind of genius document in that while certain of its provisions are quite specific and you know, it just doesn't matter how times and circumstances change. We still have a Senate, we still have a House of Representatives, and they're still elected the same way, and all manner of things like that. That the framers, and then in subsequent amendments, and especially with respect to the Civil War amendments, the 14th and 13th and 14th and 15th amendments, wrote some provisions broadly, generally, and this goes back to what Chief Justice Roberts said in that quote that you mentioned. And I think actually, if I remember it correctly, Chief Justice Roberts said it would be wrong to give general provisions a crabbed interpretation. That the point of these general provisions is to ensure that the principles that the framers held so dear, or that the ratifiers of the 14th Amendment held so dear, that those principles would continue to apply throughout the ages for our posterity. And that's so with respect to, you know, a number of ways in which the government can deprive people of equal protection of the laws or violate people's liberty.
Well, I agree with that comment. Last year, the Supreme Court chipped away at the existing precedent in Brown v. Board of Education. So these are real concerns. I think the framers of our Constitution would have been proud of Brown v. Board of Education, even though at that time, as you know, African Americans were not included in the Constitution in a full sense. But in that case of Parents versus Seattle School District, the court held that voluntary integration programs were unconstitutional, chipping away at Brown v. Board of Education. Justice Breyer, writing the dissent, said, "What happened to stare decisis?" I noticed Senator Cornyn talked about following legal precedent. Well, Justice Breyer was concerned about that. He said, "To invalidate the plans under review is to threaten the promise of Brown. The plurality position, I fear, would break that promise. This is a decision that the court and the nation will come to regret." Do you believe that decisions like Brown v. Board of Education are still relevant today and are precedent for the court to carry out what that court did in advancing we the people for all?
Senator, I hope and I know that Brown v. Board of Education and the principles that Brown v. Board of Education set forth are still relevant today, and they're the principles that the Equal Protection Clause has set forth. And the idea of equality under law is a fundamental American ideal, a fundamental American value, a fundamental American constitutional value. And one of the court's most important missions is to ensure that that value remains strong over time.
Well, let me move on from education to voting rights on the civil rights agenda. It took a long time. A lot of people worked hard. People give up their lives in order that we have the right to vote and expanded the right to vote. It took constitutional amendments, and even the Civil Rights Act of 1964 failed to address the hurdles that used to exclude black voters and poor white voters. So Congress passed the Voting Rights Act of 1965. So it was difficult for us to expand voting rights. And we have challenges today as to whether we can do what we have done. There was just recently a Supreme Court decision of Northwest Mudd that didn't directly deal with the issue of whether Congress has the right to continue the covered jurisdictions with preclearance. But it raises the question as to whether Congress has the constitutional power to protect minority voting rights. So my question to you is, you have said several times, without reference to this specific issue, that you will give due deference to Congress. I want to put it in context to where we believe there is need to expand protection under our Constitution. And will you give due deference to congressional actions where Congress is pretty clear? This is not where Congress is saying X and you know what X is. This is not substituting a Y for X, which I heard you say you don't believe is right. Will you give due deference to Congress where we are expanding protections under the Constitution?
Well, Senator Cardin, you raised the question of the scope of Congress's Section 5 power, Section 5 of the 14th Amendment, which gives Congress the ability to enforce the 14th Amendment. And the scope of that power has been an issue in several recent cases. In the case of Bernie, which I believe Senator Specter referred to earlier, the court said that it wanted to distinguish between Congress's ability to enforce, to remedy 14th Amendment violations, and also to prevent 14th Amendment violations on the one hand, which was appropriate, and on the other hand, what the court found in Bernie was not appropriate, was the court acting under that Section 5 power to change the constitutional rights that had been found by the court. So that's the line that the court has developed in Bernie and subsequent cases, which is Congress clearly has the authority to remedy and prevent 14th Amendment violations, but doesn't have the authority essentially on its own to change the meaning of the 14th Amendment.
And I understand the point that was before the court. I guess my point is that voting restrictions today still exist. And we who are involved in the political system understand it directly.
Yes, and I should say, of course, the 15th Amendment has its own enforcement provision, and the Voting Rights Act was passed under that enforcement provision. I think it's undeniable that the Voting Rights Act has been a major historic achievement for this nation. There, of course, may be a case that will come before the court on the question of the constitutionality of certain provisions or the Voting Rights Act generally. That case, that issue was potentially before the court last year. The court did avoid it and resolved the case on statutory grounds. It was a case that the Solicitor General's office filed a brief on in strong support of the Voting Rights Act. But it's not likely to be the last time that the court will consider those issues, and Congress clearly has an important role in this area, and the exact scope of that role is going to be addressed in future cases.
Thank you for that response. I find that comforting. I just point out that we lived through the election procedures, and we see obstacles in the way of voters. And in my own election in 2006, it was undeniable that the lines in the predominantly African-American voting places were 3, 4, 5 times as long as other communities, that there was targeted information sent out to tell voters in minority districts to vote on Wednesday rather than Tuesday. There were direct efforts made to diminish minority voting. It exists today, and Congress is trying to take action in this area. And I just urge you, because voting is so fundamental to our system, that when Congress acts to try to expand rights, the statements you've made about deference to the congressional branch, I think, is particularly important. Let me move to I just want to cover very quickly, because I know Citizens United has been covered over and over again here. But to me, it's a fundamental question, because voting doesn't mean much unless you have fair and open elections. And President Lincoln said 100 years ago, "I see in the near future a crisis approaching that unnerves me and causes me to tremble for the safety of my country. Corporations have been enthroned, and an era of corruption in high places will follow. And the money power of the country will endeavor to prolong its reign by working upon the prejudices of people until the wealth is aggregated in a few hands and the republic is destroyed." So I do worry about the impact of corporate contributions to the integrity of our election system. I chair the Helsinki Commission, which monitors human rights internationally. One of our principal objectives is to make sure we have free and fair elections in Europe, North America, and Central Asia. Well, my colleagues are now monitoring U.S. elections. They want to make sure, as we have signed on to these accords, that our elections are free and fair. My point is that Citizens United, to many of us, is a step backwards. And once again, Congress has acted in this area. And there's legal precedent. And I know this is a case that's already been decided and we're taking action, but I just want to weigh in to say that I think it's critically important that you follow, when you can, legal precedent and congressional dictate. Let me just change to a different subject that is on everyone's mind today, and that's what's happening in the Gulf of Mexico. As a senator from a coastal state of Maryland, I am deeply concerned about the damages that have been caused to our environment, to businesses, individuals, the loss of life in the Gulf of Mexico. Congress has passed environmental laws. Again, they weren't easy. We passed the Clean Air Act, the Clean Water Act, the National Environmental Policy Act, the Endangered Species Act, the Safe Drinking Water Act, and Superfund. Senator Feinstein questioned you as to the legislative intent to have certain areas covered in our wetlands, in which the Rapinos Supreme Court case was a huge step backwards, again, rejecting congressional intent. And then in Exxon versus Baker, we saw a restriction on the full coverage of damages in the Exxon Valdez matter. In my view, the court has weakened environmental protections that were hard fought here in Congress. Do you agree that the federal government, working with the states have a unique role in protecting our environment, and that the government must hold public lands and waters in trust for future generations? And will you give deference to Congress as we attempt to carry out that mandate?
Well, Congress certainly has broad authority under the Constitution to enact legislation involving protection of the environment. And I think that when Congress enacts such legislation, the job of the courts is to construe it consistent with congressional intent.
Thank you. I also want to cover some employment cases, because I think, again, we're seeing a chipping away of the rights. A couple of my colleagues have talked about the Gross case, which the court rejected a long-standing test to deal with age discrimination in the workplace. I could also talk about the Ledbetter case, in which the court on gender discrimination took the the tests, which I find incredible to believe that Lily Ledbetter was supposed to know about her discrimination, even though it was impossible to discover it, and she was barred by statute of limitations. Now, we've corrected the Lily Ledbetter case by further congressional action. But you talk about how we can make sure that every American gets a fair shake. Now, how do I explain to a 50-some-year-old woman with a couple children who is fired after 25 years in the workforce because the employer wants to hire someone half her age and pay 1/3 the salary? How is she getting a fair shake when the Supreme Court changes the test in order to avoid the current protections we thought we had in law against age discrimination?
Well, Senator Cardin, I've pretty consistently said that I don't want to, grade or give a thumbs up or a thumbs down on particular Supreme Court cases. I do think that with respect to any statute, discrimination statutes or any other, that the job of the court is to construe the legislation as Congress meant for the legislation to be construed. And that's difficult sometimes, but that's the goal, is to make sure that the court is not doing, deciding a case in a way in which, it would like the statute to read it, that the court is deciding the case according to the way Congress wanted the statute to be applied.
Well, thank you. I think that was a pretty complete answer. And by the way, I just really want to thank you for the complete answers you're giving us. In response to Senator Graham, you gave us high grades. I want to give you high grades on being responsive to the questions. I think you've been very direct where you can be, and I thank you for that openness to the committee. I want to cover one other area of inclusion on we the people, including all. Right now in 30 states, an individual can still be fired for their sexual orientation, or he or she have no recourse. An alarming 39% of the self-identified LGBT workers in America have reported some form of workplace harassment or discrimination, and yet they have no legal recourse in nearly 2/3 of our states. This is contrary to the legal expectation of fairness, or, as you say, a fair shake for all Americans. And Congress has an obligation to stop this discrimination. Now, the state of Maryland has taken action, and I congratulate our legislature and governor for acting in this area. We have a similar effort pending in the Congress of the United States, and it has the support of 202 co-sponsors in the House of Representatives and 45 co-sponsors in the Senate, and I'm proud to be an original co-sponsor that would provide protection in the workplace for LGBT. My reason for bringing this up is that we expect to pass this bill. It's not going to be easy, but we expect to get this protection passed. I am certain there will be a legal challenge. We usually find that the case. Once again, do you believe that to clarify the definition of we the people so that all Americans are included in that and have protection of law? And again, will you give more deference to Congress as we try to create a more perfect union?
Well, the policy decision, Senator Cardin, is up to Congress, and the questions that might come before the court are questions, if they're statutory in nature, they would be appropriately addressed by the court asking what Congress intended.
Thank you. I wanted to save about 5 minutes at the end for somewhat easier rounds of questions so you can catch your breath a little bit. You've been going all day. So I want to talk about pro bono. And I want to congratulate you for your work at Harvard in expanding clinical experiences for your students. But I want to tell you the challenges we have. According to recent Legal Service Corporation studies, each legal aid attorney serves over 6,800 people, while there's one private attorney for every 525 people in the nation. This is not equal justice under the law. Recent studies have shown that every person who receives free legal assistance at least one person is turned away due to lack of resources at the agencies. And this has only gotten worse as our economy has gotten worse. Many of the resources in which legal aid bureaus depend upon are the IOLTA funds, which, as you know, have become much more difficult for legal service agencies to get. So unfortunately today, many low-income individuals are denied the opportunity for legal services, which is hardly equal justice under the law, which is what I think we all want to achieve. And the type of cases they handle are like pregnant women who are being battered by their husbands, helping homeowners face foreclosure, allowing them to stay in their homes, helping employees who are discriminated against in the workplace due to race or gender or religious preference, helping people with disabilities, and those types of the cases. During my years, I chaired the Maryland Legal Services Corporation. I helped to establish the clinical programs at Maryland Law School, which I found to be very helpful in training new lawyers who are sensitive to public service, but also providing a great deal of services for people who needed help. So now looking around the country, 36 law schools have pro bono or public service requirements. As Dean Kagan, I know that you instituted major improvements of expansion in the law school clinics while at Harvard. Harvard Law students must perform at least 40 hours of law-related public interest work, including working on behalf of people who cannot afford to pay for legal services. Can you tell us just briefly a little bit about your experiences at Harvard Law School to expand the number of students participating in clinical programs and what impact that had on providing help to people who otherwise would not have received adequate representation?
Senator Cardin, this is one of the things I worked hardest on at Harvard, along with a great many other people. And I think we had some significant successes, which is good because the need is so vast in this area that there's so much need for legal services, you know, of all different kinds, of people who have housing problems or have employment problems or who have problems accessing health care in ways that they need it, in all kinds of ways in which a lawyer can help them, and you know, in which this country should be able to work out a system in which such help can be provided. As you said, we very much expanded the clinical programs at Harvard during the time of my deanships. We also expanded the other kinds of pro bono opportunities open to Harvard Law School students. I think that the numbers are more than double the number of clinical placements during the time that I was dean, and the pro bono work that was done by Harvard Law School students more than doubled during that time as well. So that 40-hour-a-week requirement that you mentioned, 40-hour by graduation requirement that you mentioned, we had students who had performed 2,000 hours of pro bono by the time they graduated. And I think that the average amount of pro bono that was done by our students by the time they graduated was something like 500 hours, sort of 10 times the amount that we required of them. And I think that that's because what they discovered was this incredibly meaningful part of being a lawyer, that you can provide real services to people who need them, that you can make a difference in the world, that you can make a difference in the lives of ordinary human beings. And I think, you know, sometimes you can sit in a law school classroom and not know exactly how it all matters in the world. And then you get into one of these clinics and you do this kind of work and you see how it matters, and you see how lawyers can truly benefit people.
The University of Maryland, I believe, is attracting a much higher level student today because of its clinical programs. Students want these opportunities, and I'm proud that I'm proud that we've instituted in Maryland, and I think what you have instituted in Harvard also gives you a better diversity of student body that will help in the mission at the law school. One last question, just very briefly. The ABA requires, as part of our legal ethics, to participate in pro bono. How well do you think we're doing as a legal profession on on pro bono work, and what can you do as a justice to help advance these issues?
Well, we can surely do better, and I think the justices, the question of what the justices say, and how the justices approach these big questions about the legal profession is something that I would want to talk with my colleagues about if the Senate sees fit to confirm me. But I think that there's got to be a role for Supreme Court justices, given the positions that they have, given the visibility that they have, to try to work for appropriate, try to make sure that the practice of law, the legal profession, really lives up to the ideals that it has.